So let's talk about what happens if you file a patent application and you claim multiple inventions within that same patent application. What happens to your application? So in a situation where you file a patent application and you have multiple inventions within the application, there are several approaches that you can take. The first approach is to try to claim those multiple inventions in the same application. Now, if you do that, more likely than not, what's going to happen is the patent examiner, upon receiving that application, is going to look at those claims, see that they are different inventions, and issue an office action to you, which includes what's called a restriction requirement. A restriction requirement means that the USPTO patent examiner made a determination that your patent application includes multiple inventions. Now, there is a requirement that the patent examiner has to meet before that examiner can issue a restriction requirement. And those requirements are that the examiner has to make the determination that the inventions are independent or distinct, and that there would be a serious search or examination burden on the examiner if the examiner were forced to search and examine those different inventions. So let's start with the first requirement. I want to make sure that the word independent, in terms of the inventions being independent, isn't confused with the idea of an independent claim. When you file a utility patent application, the standard filing fee that you pay as an applicant gives you 3 independent claims and 20 claims total in the application. Now, that being said, you're allowed to have more claims in an application. In fact, you can have as many claims as you would like, but if you have independent claims exceeding 3, you have to pay additional claim fees for those independent claims. Also, if you have a total number of claims more than 20 claims in the application, you have to pay an additional fee for each claim over 20 claims. So if you're adding a large number of claims to a single patent application, the number of claim fees that are going to need to be paid is going to add up very quickly, and it might turn out that it's less expensive to file another patent application with those claims rather than to pay all those additional claim fees in a single application. The main point I'm trying to make here is that the independent claims, the 3 independent claims that you would file with a utility application, in most cases, even though they're independent claims, they would be directed to the same inventive subject matter. In other words, they would be claims that would be directed to the same invention. Now, the restriction requirement, the word independent in the examiner's requirement for making a restriction requirement is a different independence. That independence means that the claims that the examiner is looking at are for inventions that can stand alone. The inventions are independent in and of itself. So it's a little bit confusing. I hope that I'm being clear enough on this, but if I'm not, feel free to ask additional questions in the comments. The main thing to understand is that you can have several independent claims in a utility application that are directed to the same inventive subject matter. In the case of having multiple inventions in a patent application, what we're talking about there is that the claims, whether they're independent or not independent, they're directed toward different inventions. So the examiner would look at claim 1 and look at maybe claim 10, which is another independent claim, and would say, these 2 claims are for different subject matter. Each of those claims is directed toward an independent, separate invention. So that's what we mean here by the word independent versus independent when we talk about independent claims. For more information about independent claims versus dependent claims, take a look at my video on independent versus dependent claims, linked somewhere over here. Now, the second requirement for the examiner is that it would be a serious search or examination burden. So what that usually means is that if you look at those 2 or more claims, however many inventions the examiner believes that you have in your application, each one of them would require the examiner to perform a search in what's called a different art class or subclass. So the USPTO divides technology areas into different classes and subclasses. And those classes and subclasses are what the examiner uses to perform the search on your claims to look for prior art. If one invention is found to be in one class and another invention in a totally different class, other subclasses that may not necessarily be related to each other, that would be enough, more likely than not, to constitute that unreasonable or serious search burden on the examiner so that the examiner could impose this restriction requirement.